All right, guys. So it sounded like everything was coming through okay. Sounded like the audio was okay. I hope that is the case. I hate to get done, check back and see that it was all for naught. I don't perceive this to be a long lecture today. We're going to kind of pick up where we left off on Monday, which was getting through Article 4 and 5 of your Constitution. They're not very long articles. I think they're very important. It's all important, obviously, but these two articles, Article 4 and Article 5, are important. Article 4 in terms of that concept of full faith and credit and privileges and immunities and how states come into the Constitution, and then 5 really about how to amend the Constitution. And a recognition again that each state will be protected in its right to have a Republican form of government, which we defined in last Monday's lecture. Again, basically a Republican form of government is a representative democracy where you and I get to pick our voices who will represent our interests when dealing with government, right? So when we build, formulate, and adopt, right, the identifying of a problem, the coming up with a solution, right, that major component of what government ultimately does in its process of deciding who gets what, we, through our representatives, make those determinations, and then government, right, carries it out. It's then government's job to carry it out, and then the courts, they ultimately do the evaluation to ensure that what was carried out was what was required or requested, and that it's constitutional if we want to pull in judicial review, Marbury versus Madison, into this whole process of what the role of the court should be. But this role right here, this is where that Republican form of government comes in. Identifying the problem, coming up with a solution, choosing the best solution, that's for us to do through our representatives, the representatives we choose, not to be dictated to us, not to be chosen for us, but that we choose, right? That Republican form of government. And as I said, that becomes a little sloppy when we get to the 14th Amendment, the Reconstruction Amendments after the Civil War. Amending the Constitution, again, when we talk about the courts, when we talk about judges, I don't have a way, as I said, to actually do a screen share with you through YouTube. They used to have a process for it that was connecting through Google and Google Hangouts, but Google has since removed that. And I can find secondary sources, right, to download some software that I can then do what we see a lot of YouTube videoers do in their own video presentations, right? Sharing the screen, like you see it a lot of time for gaming, right? So sharing a game screen, and then in the corner there's your the YouTuber. But the college doesn't really appreciate when we just simply download outside software onto their computer system. So I'm trying to find a workaround to this. I know, again, we could simply use Teams or simply use Zoom, but it's a little bit more cumbersome for me to try to do that. And this is these videos, I want them to have some shelf life, be able to incorporate them into future classes. Okay, so I guess kind of a short a workaround where I download software onto the computer. At least we have some access to our system here at KCC that gives us the overhead projector and gives us access to the World Wide Web. Now, again, I know this is not optimal, probably very difficult to read where I'm at and how I'm going to get there, but this is the Supreme Court's website. So supremecourt.gov will take you to that third branch of government, and I wanted to sort of back up as we think about the role of the courts in interpreting the Constitution and that process for amending the Constitution when we don't believe that we have the right fit between the national government and the states. In other words, that the contract itself isn't doing what we thought or what we believe it should do, rather than just simply allow the courts or Congress to bend or fold or make it up as they go along. We should follow the process as intended, or amend that process out of the Constitution altogether, right? If we want to simply say Congress should do or can do whatever it is that is necessary, since it represents the people, and the people should be in charge of their government, and we shouldn't be holding to some stodgy Constitution that has outlived its usefulness, then we don't have to amend the Constitution and to afford the federal government more rights or remove limits from the federal government. If that's the case, then take it out of the Constitution. And there's a process to do that. It's in the Constitution to take it out of the Constitution. Now, again, I know that that's counterintuitive, kind of an oxymoron. We don't want to follow the Constitution, so why would we follow the Constitution to take out that we have to follow the Constitution and amending the Constitution by going to Article 5 and going through those procedures? I understand. But the point is it's in there. And as we go over Article 5, we're going to talk a little bit about how to amend the Constitution. And there's two ways to do that. One is through how all amendments to the Constitution have been carried out, and that is through Congress presenting to the states changes to the contract, and then through the state legislatures their agreement or not to those amendments proposed. The other way to do that is for the states to propose amendments to the Constitution, right? So you've got these two parties. Talked about this as a contract all along. You've got these two parties, the national government as a party and the states as a party, and they share power. That's our federal system of government. But in that sharing of power, if the states would deem it better for the states if they were to change this relationship, there's a process to do that, and they would propose, hey, how about we do this? If the federal government would like to change that relationship, then they can also propose it. They can propose it, right, acting in the interest of the states. They can propose it from that interest, right? And if they don't choose to do that, or for whatever reason we can't get to those high numbers to actually alter that contract, then the states themselves can do that. Again, still takes high numbers, 2/3, either 2/3 of the states, right? 2/3 of the 50 states, which would be 54. Would be 34 states to start the process to amend the Constitution, or it would be 2/3 of the House and 2/3 of the Senate, both chambers, to agree to an amendment that would then go to the states. In either case, whatever the proposals are, whatever the amended proposals are, they would go to the state legislatures for the state legislatures, or to ratifying delegations. That determination will be made by Congress, to ratifying delegations, and either the state legislatures or the ratifying delegations by 3/4 vote, right, 3/4 vote, would have to agree to whatever those changes are, whether they come from the Congress or they come through this process we'll call a Convention of States. They still have to go to all of the 50 states, and 3/4 of the states have to agree to those changes. Okay, so. And we're going to, well, anyway, I'm going to come back to that in a minute. I did want to, again, share with you some of the uniqueness of this website and our ability to kind of gain some insight as to how your court operates, your federal U.S. Supreme Court operates in its hearing process. In addition to that, Amy Coney Barrett, as we know, has just been appointed to the U.S. Supreme Court. I said on Tuesday that was likely, on Monday that was likely to happen, and lo and behold, it did. And so now we have a full cadre of 9 justices of the Supreme Court. Could that get larger? Could that grow? The idea of growing it and then packing it is something that's been talked about. It's kind of a heated discussion on the campaign trail. There's no constitutional requirement that it be 9. It could be larger, it could be smaller. But once there's a vacancy, ultimately the president appoints. And my assumption is, if the president were to appoint and Congress were to consent to that appointment, then you could add justices to the Supreme Court. Our number just happens to be 9, and it has traditionally has been 9 for quite some time. Okay, so this website, Supreme Court, one word, .gov. The up towards the along this top here, you got opinions. You got filings and rulings. You've got oral arguments, case documents, news media, and about the court. And then the press release regarding Amy Coney Barrett's oath ceremony is here as well. And it was really interesting. I encourage you to take a look at her comments as to how she's going to rule. Everything that we've been talking about on forming the opinions from the bench is, hey, how's it going? I'm actually live. Dr. Jakeway is joining us right now. If anybody has Dr. Jakeway and you haven't been able to get a hold of him, he's on campus right now. Come in quickly for those office hours. So
thanks for that.
Well, I was just going to take students to this kind of the website, the Supreme Court website, and just kind of offer some oral arguments where you can hear the argument audio, which is really kind of cool. They don't do any video in the U.S. Supreme Court, and it took forever for them to actually do any kind of even audio. Everything had to come out via transcript afterwards with the chalk drawings. But here's some of the more recent arguments. I don't have.
The first case today is number 19309, John Carney, Governor of Delaware, versus James Adams. Mr. McConnell.
Mr. Chief Justice, may it please the court. The fundamental feature of our system of federalism, recognized most clearly in Gregory versus Ashcroft, is that states have broad leeway in setting qualifications for their high-ranking officials, including their judges. Delaware has used that freedom to create a system unique among the states with constitutionally mandated political balance for its judiciary, with the result that Delaware's courts are widely regarded as the least partisan and most professional in the nation. The Third Circuit has upended that system based on an implausible reading of this court's political patronage cases. Orod and Branty expressly permit using political affiliation for appointments to high-level discretionary positions. But even if we're wrong about that, the Delaware provisions serve a compelling interest in creating a uniquely balanced and nonpartisan judiciary. Now, to make matters worse, the Third Circuit invalidated the bare majority provision based solely on severability, despite having found that Mr. Adams has no standing to challenge that requirement. That analysis directly conflicts with both federal and state severability doctrines. There is no doubt whatsoever that the bare majority requirement can stand on its own. It stood on its own for more than 50 years, from 1897 to 1951. It stands on its own with respect to 2 of Delaware's 5 constitutional courts even today. There is not the slightest reason to believe that Delaware's constitutional drafters would eliminate the bare majority requirement if they knew the major party provision would be struck down. That said, both provisions of the Delaware Constitution passed muster under the First Amendment, and Mr. Adams, who passed up the chance to apply for a host of judgeships both before and after changing party affiliation, lacks standing to challenge either one. I look forward to your question.
Well, Mr. McConnell, I'd like to begin with the standing issue. Our cases, like Gratz and Northeastern Florida, require that a plaintiff injured by being excluded from competing for a position need only establish that he's ready and able to apply for it. Don't you think he's ready and able?
All right, so I'm just going to pause it here for just a second. So again, what you're hearing is you're not hearing the audio of the case that was just heard on the 5th. So there's a little bit of lag time before any cases heard actually get posted onto the website. But again, this immediate ability to hear cases is something that's fairly new in the system. That was the opening statement of the individual who's presenting their case, and then it goes right into the different justices asking these questions. And again, as we talked about in class, there's an etiquette to that process in terms of deferring to the senior justices if 2 of the justices happen to ask a question at the same time. But it's all timed, and there are lights on the dais of the individuals doing the speaking, not the justices, but those individuals who are presenting their case and then answering questions. And then it switches to the next side, and then there's some rebuttal time. And in fact, you can actually click on the argument transcripts, right? And so you can just do the argument transcripts. So this is 68 pages. And so this actually follows the individuals who are speaking, right? Mr. McConnell, we heard that, and then he gave his background. And again, I don't really know the background to this case in particular. There are some, they make their way to the U.S. Supreme Court. You can bet that the decision to hear the case is of great importance. And so it's probably something that's it's very interesting. And so you have this audio transcript that you can follow along as you're listening to the justices. Older cases that have been on for a while, may be edited to also include a picture of who the justice is who's speaking at any given time. So it has a picture of all the justices on the bench, and as one speaks, their picture lights up and you can tell who the individual is who's talking at the time. But again, there's no TV cameras allowed into the courts. It's all based on audio now. And as I had indicated earlier, originally it wasn't even audio. You had basically an individual taking notes, right? So a reporter taking notes, hitting the highlights, and then you had the sketch artist in there with the chalk drawings, and that's how it was presented out. And then later on, the audio would come out after basically the end of the term for the justices in terms of their hearings. The judges sit on the bench. In other words, they'll hear opinions from October to June, and then take June, July, August, September pretty much off. When I say off, they're just not hearing cases. And then they'll hear cases again starting in October. How do they choose the cases to hear? This is interesting. Again, there's no constitutional requirement that they go this way, but this is a long-standing rule, and it's, from what we know, it's called the rule of four. There are four judges. Four of the justices, four of the 9 justices, have to agree to hear a case before the case is heard. Again, the rule of four. There are 9 justices, as we indicate. But if 4 get together and say, "Look, this is a case that we believe should be heard," that's the first hurdle. Again, there's not a guarantee that the case will be heard, but if you can't get 4 of the 9 justices to agree that this is a case that really should be heard within our limited scope of time frame, and the fact that we have some 7,000 or so cases that have been appealed to us, and we're going to hear about 110 or so, then you've got to make some decisions as to which are heard and which aren't. And that first threshold is that rule of 4. In addition to that, I think what goes on too, and probably getting to the number 4 and number of justices even beyond to agree to hear a case when you have such limited time, is they would, I assume, and based upon what clerks have reported out, individuals who've worked with justices have reported out, that there's some horse trading that goes on. A little bit of this, I hear your case, you hear my case, but in context to what's the impact of the United States in the United States. And so how wide reaching is this case? Is it very narrow? Or there are a number of court cases working their way up through the system that eventually we can set case law and deal with all of those court cases with one ruling. A number of years ago, there was some question as to whether or not universities could, for lack of a better term, reverse discriminate, right, in terms of holding seats open and extending opportunities to individuals who are in racial minority classes or gender minority classes of individuals to the detriment of those in the quote unquote majority, and having some type of affirmative action programs in their admissions. And this was a court case. There were different court cases throughout the United States that were working their way up to the U.S. Supreme Court, asking the same question. The U.S. Supreme Court then took the case really for the University of Michigan and heard that case regarding whether or not there could be some affirmative action programs, if any. And the court came out and said, yes, there could be, but it can't be an overemphasis. Oftentimes the court will try to find balance. Oftentimes in the cases that they're hearing, they're not black and white. If they were black and white, there would be no need for the court to ultimately hear them unless some egregious decision was made lower in the lower court process. So trying to reach the balance is tends to be a good way to approach, I think, court cases, and certainly those that seek to alter those issues of equity and fairness and justice with freedom and liberty and how the government interacts with its citizens. And then a third, I think, feature of how the court decides which cases to hear would be the notion that there's one constitution. In other words, when a court rules or where a circuit court rules, they're making a determination as to what the Constitution means. And within that jurisdiction of the court, that court, right, whether it's a district or a circuit, then that interpretation of the Constitution is the one that must be applied by lower levels of government, right? The Supreme Court being the supreme law of the land, that's Article 6, that the decisions and how that those laws that are applied that may come against that ruling have to follow that ruling, right? And if it's appealed up and the state U.S. Supreme Court chooses not to hear the case, then that decision will stand. Well, other governments and other lesser courts outside of that circuit can point to that circuit and use that as precedent. But if there's a division amongst circuits where a circuit says the Constitution means X, and then another circuit says, no, the Constitution means Y. Now you're creating two constitutions that if I live in California, these are my rights as a citizen under the U.S. Constitution. But if I live in Michigan, these are my rights. And they may not be the same rights. And that, I think, the Constitution, the U.S. Supreme Court is loath to allow. And so those cases get priority in their hearing. Sometimes the U.S. Supreme Court will allow those divisions to stand, which is really, really odd to me. I don't think it happens often, but it did happen fairly recently when it came to the opening of government, basically the opening of government meetings using prayer, right? Using a prayer to open government meetings, and whether that was a violation of the separation of church and state of the First Amendment. The Sixth Circuit of the Supreme Court, of the Sixth Circuit Court of our U.S. court system, which Michigan is a part of, ruled that it depends on how it's ultimately presented and offered, but that government entities could indeed open their meetings with a prayer. But the Fourth Circuit deemed that was not constitutional. And that question did go up to the U.S. Supreme Court, and the U.S. Supreme Court denied to hear it. So they allow this idea that within certain areas in the United States, you can constitutionally open government meetings with a prayer or denominational prayer or whatever type of prayer, non-denominational, denominational, depending on who's offering the prayer. And in another section of the United States, you can't. And that was really odd to me. At the time, the justices, I think Scalia had passed, and so you were in a situation of four justices to four justices, and that may have been the reason that they couldn't or didn't hear the case. Maybe they couldn't get four justices who wanted to hear the case, right? That rule of four. So they denied cert, and to my knowledge, that's where we stand today. So real quick, just you have the website. You can go in and listen to the oral arguments. You could pull up the visual and read through the transcripts. Again, that's supremecourt.gov. But just to give you an idea about the circuits, and again, I know that this is not optimal, but if you keyword in Google or whatever your web engine search engine is, if you keyword United States Circuit Court map, it'll give you a map of the different circuits, and you'll see where Michigan is in that map. United States. Circuit court map. And so it auto drops it in there for you. All right, and then there's some different pictures. This one's kind of a high visual color here, maybe. All right, I can make it a little larger on our screen for us here. All right, and so this should give you some indication. Again, Michigan is right here in the 6th. Here's the 4th. I think it was a North Carolina case versus a Michigan case regarding prayer and public meetings. But this is the Michigan circuit. I don't know if you could probably see this. You probably can't, but there's a dashed line that goes through the center of Michigan. So these are the two different districts. There's a Western District of Michigan, and then there's an Eastern District of Michigan. And then it looks like there would be a Northern District of Ohio and a Southern District of Ohio. And so these are the different divisions within the states that have a few different judges within the districts. Way over here is the 9th Circuit Court, right? Includes Hawaii, Guam, and Alaska. All right, and this is the 1st Circuit Court, which also includes Puerto Rico. Okay, and then here's the 3rd Circuit Court. The 3rd Circuit Court. And then you have also the DC Circuit, right? The DC Circuit, which is its own circuit as well. And it's the federal circuit and also includes the Supreme Court, but the federal circuit. So cases that are of a federal nature or start as a federal nature will go into that setting. You have a right, when we get to the amendments, for example, to be tried in the district which the crime happened. So, you know, where your districts are, the district is, that's important. And remember, these are judges that are appointed for life, and the appointment and the confirmation, it has an impact. Who did the appointing? What were they looking for? And if we think again about judicial activism versus judicial restraint or constructionism or originalism, it'll have an impact on how the Constitution is applied to the actions of government. Okay. So I don't have that. Again, I would encourage individuals to take a look at Amy Coney Barrett's comments as she was appointed on Monday night. She was sworn in by Justice Thomas. There was another Chief Justice Roberts does another swearing in a private ceremony, but the public ceremony was just Justice Clarence Thomas on Monday night. Let's see if I can find it here real quick. I think Cohen Barrett's personal confirmation statement. So I'm just trying to get to the right. That's our opening statement. I'm not looking for opening statement. I'm looking for her statement on her confirmation statement. Well, at any rate, I would just encourage you to take a look at it. It just gives a good understanding of her approach to the court, and it fits well with what we've been talking about in our lecture. Okay, so just want to kind of change gears here real quick. Go back to this idea of how we amend the Constitution. What's in Article 1? What's in Article 5 of your Constitution regarding amending it? And there are, as pointed out, two processes for that, right? And some special numbers to keep in mind, 2/3 and 3/4, okay? The 2/3 is what's necessary either through Congress, and that includes both your House of Representatives and your Senate. So 2/3 your House, 2/3 your Senate, right? Or 2/3 of the state legislatures, right? Which oftentimes include both the House and Senate as well, except for Nebraska. But so those entities together have to come up with a resolution, and depending on their own state constitutions, what that process is within their own state constitutions. So each state may have a different process for coming up with a resolution for amending the Constitution. Okay, and it's 2/3 of the state. So 2/3 of 50, as I said, is 34. And then you have your 2/3 of your 100 individuals, and then 2/3 of your 435 individuals. That's just to get the amendment back before the states, all right, where either three-quarters of these ratifying committees, group of delegates, or state legislatures. Again, that process will be dictated by the state constitutions. 3/4 then have to ratify whatever comes out of these state legislative initiated process or the congressional amending process. This is the way that the amendments to the Constitution, those that we have on the books, have come to the states to be either ratified or not. This is the way that all amendments to the Constitution have come. And again, this is a little bit easier process to get Congress with its majority. When I say easy, it's not meant to be easy, but in terms of keeping it contained to a smaller number of individuals, working the whip counts, working through the parties, maybe a little bit easier, less cumbersome than this process. In addition to getting the 34 states to resolve to amend the Constitution, there's not a specific amendment that comes from this. There's a call to convention for the purpose of proposing amendments or an amendment. Okay, so there's the call to convention, right, which takes the 2/3 of the states to call this convention for then the purpose of offering amendments through the convention process, like how our Constitution was ultimately presented out. And then whatever amendments are properly passed by this convention of the states, they still go back to the states to be ratified, just as if they had come out of the Congress. Now, I'm a supporter of the idea of the Convention of States. I don't necessarily believe we have to or should be, I believe that Congress could also offer amendments at any time, and we could take those amendments on. But the problem with Congress ultimately offering amendments is that this, again, we have these two players in our federal system. We have the states and the interest of the states, and then we have the federal government and the interest of the federal government. And again, I know that it's the states that send their representatives, but through ideology, those individuals, when they go to Washington for whatever reason, don't always represent the best interest of their state, but more so may best represent their interest of their ideology, right? What the national policies that go towards that individual who's been elected, their ideology. And again, you don't tend to get elected if you don't reflect the interest and the approval of your district. But having said that, we do have an issue with incumbency, where the incumbent individual who's elected to office tends to have a much greater chance of being reelected than any challenger has. And so at our state level, in the state of Michigan, for example, we've put term limits in place that limit this long-serving, long-time advantage to individuals in office, and help to shake up and to change that representation. Some people support term limits, other people don't support term limits. There are arguments for and against on both sides, and they're fairly good arguments. The best argument, I think, against term limits is that in a Republican form of government, I should be able to elect the person who I want without some group of individuals from outside of my area telling me I can't elect that individual any longer. All right. The flip side to that is that there's such an advantage to incumbency, and it does have a tendency to leave individuals with I don't know, a sense of not being represented by someone who really truly has walked a mile in their shoes. Particularly when you get to the federal level, those individuals who go on to Washington D.C. again, there's a different era about those elected individuals in terms of who they are. No longer are they maybe perceived as the employee of their district and begin to think of themselves as something greater than. And I think that in our system, at least early on, the idea was you send the citizen legislator, those individuals who walk and then live by the laws they pass, to Washington to serve a short period of time, to come back and to pass that baton. And I think that was the mentality of the framers. And by tradition early on, that's how it worked. They were short terms. They were individuals who stayed for a shorter period of time, and ultimately came back and passed the baton. The benefit to that is that again, you have individuals who have fresh ideas as how the laws impact them directly, and not those individuals who tend to be privileged in terms of their their status as a U.S. elected senator or a U.S. elected congressman. It's hard to make that connection of the individual who's living in a rough area, an area that may be high poverty, or an area to make that connection to an individual who may have been in office now for 30 some years and hasn't felt or hasn't been around and has been devoid of that part of their district that they represent, and to then ask them to empathize regarding the full needs of their district. And so term limits, we have them at the state level, have been proposed at the federal level. So here's a question. Do you really think that the group of senators and representatives, that we can get to 2/3 of both chambers asking these individuals to limit their time there, asking them to limit what's a pretty good gig once they get there? And so individuals, I think probably rightfully so, would argue that an amendment like that would really only come from a convention of states, where it would get the support necessary to then get to the state legislatures for them to pass. Balancing the budget, a balanced budget amendment, term limits, different things that actually rein in or reel in the national government, the federal government, and that privilege. It's hard to it's hard to put that in front of those individuals who are benefiting, just like we talked about patronage, and expect that those individuals will rein it in. So you've got this two-party system where, again, those recognizing that there may be times where those individuals in Washington have different interests than the states they maybe represent, and then to bring that back in, potentially, if necessary, a process for the state legislatures to ultimately to do that. And in that process, you call the convention. And then the convention of individuals from the states will come together, and each state will vote as a block of one, and it will determine those amendments as it passes it out of the process that will go back before the states for the states to ratify. And some individuals are very sheepish about that, very concerned that there's going to be outside influences, and there's going to outside influences. Where in this process isn't there outside influences? Yes, but there are agendas. Where in this process aren't there agendas? At the end of the day, if 3/4 of the state legislatures or ratifying delegations say that this is what we want, then ultimately that's our system of constitutional government. So I think that those arguments that are meant to kind of induce fear in this process of getting citizens together to devise amendments that would make the relationship, in their opinion, between the states and the national government better, to then put those before the states, that somehow that fear being pushed forward, I just think it falls flat. I think that there are enough safeguards in the process. So at any rate, and in my mind anyway, this is a better process than simply allowing the courts to ultimately make it up as they go along, or Congress to make it up as they go along, which seems to not readily happen all the time, but you're in danger of that. And again, at stake with the the appointment of this last Supreme Court justice was, how is the court going to evaluate those actions of Congress in their mind in terms of a constitution that's either static and solid, rigid, or one that is flexible and breathing and evolving, right? So the Convention of States, if you're ever interested in taking a look at the Convention of States, COS, Convention of States, there's some information out there. I would say it's a growing movement. It doesn't move fast, because again, you got to get 3/4 of the legislature, 2/3 first of the legislature to agree, and then 3/4 of the legislature to be open, legislatures to be open to these changes, or the ratifying conventions to be open to any changes that come out of this Convention of States. So if you just go to Convention of States, all one word, .com, take a look at it. So this latest news, take action, resources, right? So there's information here. Sign the petition is still a petition drive. Why call a convention? This gives you all kinds of background, how it works, right? These are different states that have active legislation. Michigan's one of the states that has active legislation. These are the states, these in green, that have passed, right, in both chambers, the Convention of State resolution. So all of these green states for the resolution to actually call the convention. And you got to get to 34. Remember that. You got to get to 34. There's some, in my opinion, there's some question as to whether or not the issue of specifically a balanced budget amendment had reached the number of 34. But regardless, this is to call the Convention of States. It's legislation that's active and it's passed. And you can see again, it's moving. It's getting there. And once that happens, then there's a process of individuals, representatives from the states, and they'll they'll be the individuals who gain basic, those will be the individuals who offer or present different amendments to the state legislatures of the ratifying conventions. And I just think that process would be very, very interesting. And I do think that if we're going to live by a constitution as written versus one that's living, breathing, and changes via the whims of 5 justices, that we may need to get into the Constitution and actually solidify some writing and impress upon those justices that are that are on the bench that this is what the people want from their government, written, enumerated from individuals of today, and not trying to rely on figuring out context to the content of a constitution that was written 40 some years ago. So at any rate, that would be something I check out. It fits right in with Article 5 of our Constitution, how to amend or change the Constitution. As noted, the amendments that we have that are in the Constitution today, including the Bill of Rights, all started via the process of Congress, 2/3 of both chambers, passing them out then to the states or to ratifying delegations for their consideration. All right, so conventionofstates.com, or we've got the conventionofstates.com or the Supreme Court.gov. If you take a look at both of those websites, that kind of help to fill in any pieces that we may have missed in our lectures. Don't forget to look at those lecture notes online. Starting next week, then we'll get into Articles 6 and 7 and close out the Constitution, and then really actually spend time on its application. All right, you guys, if you have any questions, don't hesitate to email me. Otherwise, get online, take a look at those lecture notes, stay on top of the class. Don't miss those journals. Students who keep missing the journals and the journal deadline, don't miss those. Those points do add up. And with that, we'll call it a day.